Thank you for coming to the annual Mirror of Justice lecture hosted by the John Paul II Guild of Catholic Lawyers. My name is Alex Hamilton. I'm the president.
I'm Elizabeth. I'm the vice president of events.
And we're just going to start with a quick prayer. In the name of the Father, and the Son, and the Holy Spirit. Amen. Come, Holy Spirit, fill the hearts of your faithful, and enkindle them the fire of love. Send forth your Spirit, and you shall be created, and you will renew the face of the earth. And let's also say a quick prayer for passing of our classmate, Alexei Brzezinkas. Eternal rest, grant unto him, O Lord. May perpetual light shine upon him. May he rest in peace. Amen. Amen. And Father, Son, and Spirit. Amen.
Yeah, just a little bit about the namesake of this award, Mary, Mirror of Justice, from St. John Henry Newman's Meditations and Devotions. He writes, "When Our Lady is called the Mirror of Justice, it is meant to say that she is the mirror of sanctity, holiness, supernatural goodness. But what is meant by calling her a mirror? A mirror is a surface which reflects, such as still water, polished steel, or a looking glass. What did Mary reflect? She reflected our Lord, but he is infinite sanctity. She then, as far as she could, as a creature, reflected his divine sanctity, and therefore she is the mirror of sanctity, or as the litany says, of justice. Do we ask how she came to reflect his sanctity? It was by living with him. We see every day how like people get to each other who live with those they love. All of us perceive this. We are witnesses to it with our own eyes and ears. In the expression of their features, in their voice, in their walk, in their language, even in their handwriting, they become like each other. And so with regard to their minds, as in their opinions, their tastes, their pursuits. And again, doubtless in the state of their souls, which we do not see, whether for good or bad. Now consider that Mary loved her divine Son with an unutterable love. And consider too, she had him all to herself for 30 years. Don't we see that, as she was full of grace before she conceived him in her womb, she must have had a vast, incomprehensible sanctity when she had lived close to God for 30 years. A sanctity of angelical order, reflecting back the attributes of God with a fullness and exactness of which no saint upon earth, or hermit, or holy virgin can even remind us. Truly, then, she is the mirror of divine perfection."
Thank you. We just wanted to give you an idea of what this award's about. We always, every year, we consult our faculty advisor and pick a faculty member who kind of exemplifies or literally mirrors the virtue, the grace, the justice, mercy of God himself, and someone who glorifies God in their vocation. So without further ado, I will do a brief introduction. Our speaker and award recipient this evening is Mr. Lawrence Morris. He received his bachelor's degree in journalism and political science from Marquette University, and he worked as a reporter for a time, and he received his JD from Marquette Law School, and he was in the Army for over 30 years, where he served in various positions. He tried court-martial cases. He served in the criminal law department at the Army's law school. He worked on war crimes issues after 9/11. He served as general counsel at West Point. He served as the chief public defender of the Army. And he worked as the chief prosecutor for the war crimes trials at Guantanamo Bay, Cuba. And he's also received a Bronze Star. He currently he lives with his wife Carol, and he has 6 children and 1 grandchild. So without further ado, I will hand the mic over to Mr. Morris. Thank you.
Good afternoon, everybody, and thanks for giving your rainy Thursday afternoon. Today I want to talk some about the whole process involved in bringing justice in the area of war crimes. And the best place to start to analyze the judicial response to the September 11th attacks is 13 years before that. In December 1988, 4 days before Christmas, a bomb planted by Libyan terrorists blew up a Pan Am plane carrying 259 persons from Europe to JFK. Became known as the Lockerbie bombing because it occurred over that Scottish town and killed 11 of its citizens as well. Now, obviously, the bombing was a crime. And most any jurisdiction, most anywhere in the world would have some way of characterizing that as murder. But it nagged at a young DOJ official who was not yet 30 that it wasn't just a crime, or not simply or primarily a crime. It was an attack on the United States, maybe more broadly an attack on the West, and a fundamental violation of the law of war. While the bombers might not have had access to a passenger manifest, they knew well that this American carrier, Pan Am, was carrying mainly American passengers, as it happens, including some number of students returning home from their semesters abroad. In fact, 190 of the 259 were Americans, about 3/4. 43 were Brits, and then the remaining 26, it was 10% of the total, were victim passengers from 21 other countries. So the attack occurred on the seam between presidential administrations. Bush 41 had been elected the prior month, would take office the following month. And there was the unsurprising dip in energy at the end of an administration, compounded by Christmas, compounded further by the end of term departure of many political employees. So it is a little surprising to find that this imaginative DOJ official who wrote a memo suggesting that the Lockerbie bombers, not yet identified, be tried by military commissions, which is a judicial mechanism that had not been used since World War II. So the author's point, William Barr's point, was that using the conventional courts was insufficient, unable to bring these killers to justice in any manner that would be timely and just. And there was a need to make a point through the courts, through the system of justice, that this was an unlawful attack by unlawful combatants, and therefore to resurrect a dormant mechanism for justice that had not been used in all those years. Obviously, his recommendation wasn't accepted. We didn't have war crimes trials, but the thinking process provoked some pertinent questions to us, such as, how do you find and apprehend such suspects? How do you get information from them, both stuff they might have and statements they might give? What protections, if any protections, should they have relating to the government's collection of evidence? In what forum do you assert jurisdiction? Where do you try? Under whose laws? How do you get an accused from a place like Libya or wherever the co-conspirators might be? That compounds this problem of dealing with hostile governments that might give tacit sanctuary to terrorists. Further questions, under what procedures, like the rules and procedures we come to know as due process, and that includes what to charge them with, how to manage the evidence that might have been collected in a way that is unconventional enough that it wouldn't make it through the understandably strict processes that we have to bring in evidence. How do you ensure a defense that is sufficiently competent and independent that it produces a result that people can trust? What would be the maximum punishment? Should they be death penalty eligible? Who sits on the jury? Do you have to give them a right to appeal? And if so, how do you make that up? And how do you do this with enough speed that it accomplishes the other purposes of a justice system, which is timely justice? The farther apart it is, the more attenuated the justice, the more diminished it is, the more unsatisfactory it is to victims, to members of the public. And finally, how to communicate about all this to the important publics, to victims and people who are affected by the offenses, to a nation as a whole, and to people who would resource or shelter terrorists and are calibrating the response of the West in determining whether to take another crack. So we faced similar factors in 2001 when, a week or two after the attacks, we were told, start thinking about military commissions for the first time in 3 generations. And as a matter of definition, commissions is a historic term for what you hear colloquially called war crimes tribunals, and has nothing to do with the type of commission that's issued under the authority of the commander-in-chief to appoint someone as a military officer. So at that time, I was staff person in DC called the Chief of Criminal Law for the Department of the Army, so the task came from the Secretary of Defense to the Army to me. And we hustled and put together a team to start thinking about this. And I had been an Army colonel for 4 months at that point. So worked for the next year or so as the head of a team trying to figure out whether this old mechanism could be dusted off and how it could be employed in a way that is safe and just. So I worked at that time, went off to do other stuff, including serving as the Army's Chief Defense Counsel, then came back to it as the Chief Prosecutor and served there then from 07 to 09. So I'll draw on all that experience and talk in today. Back once more to Lockerbie. By most any measure, justice was long delayed and unsatisfactory to most families and to the US and to the UK. It ends up that remember the bombing occurred in '88, arrest warrants were issued in 1991. 8 years after that, Gaddafi produced a couple of Libyans for trial under a deal by which they would be tried under Scottish law in a Dutch courtroom. Needless to say, with no American involvement. At the end of it all, a single Libyan was convicted. In 2001, it turns out, so 13 years after the offense. Endless appeals. He was released in 2009 when the court accepted the representation that he had 3 months to live before he died of cancer, got out of jail, lived 3 more years, and basically got to choose the circumstances of his death. We in the West ended up unable to so much as lob a grenade at Libya. Nothing happened. And the US could have taken a reprisal against Libya. A reprisal is a lawful response, short of an act of war, to a violation of the law of war in retaliation for damages or loss. So for example, we could not have ourselves slaughtered 270 innocent Libyans as reprisal, or shot down one of their civilian aircraft, or bombed an orphanage. But we could have taken appropriate military action, blown up an airfield, a weapons depot, something like that. So we took from Lockerbie a sense of the limitations of relying on other sovereigns for justice, an outcome that was unsuitable for most everyone. So while the Lockerbie memo didn't get past the drawing board, a still new administration of President Bush 43 was thinking on similar lines after 9/11. Now remember, they're an administration not yet 8 months old, but they had already been looking for the opportunity to assert the primacy of the executive branch. They had a belief that prior administrations had ceded too much authority there. You remember all the discussion about the unitary, you may not remember that discussion, I remember that discussion about the unitary executive and stuff like that, to assert wherever possible the authority of the executive. So this matched up really well with that, the idea that a mechanism like this was driven by the president as commander-in-chief. We ended up drafting off of, the last time this had happened had been under Roosevelt, and there was a sort of a sweet irony in the Republicans cribbing from Roosevelt, but he had issued a military order in 1942 in a trial that we're talking about having to do with some Nazi saboteurs. And he called it a military order as opposed to an executive order to make clear that it was under the least reviewable area of presidential authority, which is your role as commander-in-chief. So commissions were validated by the Supreme Court as a result of that case in 1942, a unanimous opinion in a case called Quirin, Q-U-I-R-I-N, involving Nazi saboteurs who landed on US soil. So the case featured a sequence of events that would stun us today for the speed and the exercise of unilateral presidential authority. These saboteurs were caught on American beaches on June 13th and June 16th, 1942. Middle of June 1942, executed August 8th of that same year. During those intervening 6 weeks, they were sent to trial by President Roosevelt, charged, given defense counsel, tried secretly in a 5th floor courtroom at the Department of Justice, had their case reviewed on a writ of habeas corpus by the Supreme Court, and really phenomenal independent work by defense counsel at the time. Court issued a per curiam opinion denying cert. Next day, the tribunal, which was a board of 7 military officers, resumed the trial, convicted on the next day, and 6 out of 8 of them were given the death penalty, executed in August, and then the court publishes its full opinion a few months later. So almost unimaginable to us in modern times, but that exercise of authority validated by the Supreme Court was attractive enough for this administration to study it deeply over a couple of month period. And we started working on it in late September, and the president issued his order, standing up the process on the 14th of November. So by government speed, that's lightning speed. But remember why these guys were eligible for war crimes trial to begin with, because they were soldiers, but when they landed in New York and Florida, they had their uniforms, but then they buried them, and then they were apprehended in civilian clothes while preparing to undertake acts of espionage, blow up power plants, that sort of thing. So had they been in uniform, nothing they did would likely have been illegal. Which wouldn't mean they have gotten a free ticket home, but it would mean that they would have been held. We would have the authority to hold them as POWs at some point, have trials, or repatriate them as we would choose. But it's worth recalling the criteria in international law for determining whether somebody is a lawful combatant. These are logical, historically based reasons when you think of it. So the first one is to carry arms openly. Second one is to wear uniforms or distinctive insignia that's visible at a distance. Third is to have and follow a chain of command. And fourth is to obey the law of war. So in 2001, then, those questions raised by Lockerbie were again in play, and the same or similar figures arose again. First one, speed. The need for a relatively swift process is premised on the assumption that violators of the law of war traditionally have the least protection and only the rudiments of due process as they were necessary to ensure a just result. So a non-citizen unlawful combatant has the least authority, the least ability to plan any protection. Citizenship is still consequential. Citizenship, when you're on non-US dirt, gives you a low level of protection. So when we used to argue with my boss all the time, we would be talking to the press and all, and would want to say these, the guys we were trying had, these are those rights. My argument was always, they don't have any rights. They do have protections, and those protections are in our shared interest in having a valid outcome of trial, but they're not wrapped in the Constitution the way that an accused in a conventional U.S. court would be. Jurisdiction. A lot of discussion about jurisdiction over the person and about whether to use a U.S. forum or an exclusively U.S. forum. Obviously, 9/11 was an attack on the United States, even though citizens of 77 other nations also were killed. So we talked through, at least to have the discipline of thinking it through, the process of how would you begin to integrate who knows how many countries and all of the practical and legal mix of issues there. So never was that a realistic possibility, even though there have been times in our history where we've had soldiers from other countries join on our tribunals. And there were philosophical and practical decisions not to share jurisdiction with other countries. There were, recently at that time, there had been a sprouting of various tribunals in other countries. There had been a tribunal regarding the Balkans and Rwanda, but the reason for them was they were either a failed state or unable to operate a justice system. Sierra Leone, same thing. The country was so corrupt, people weren't going to trust their system. But there was also a punishment aspect for us. We are about the only country in the West that was still using the death penalty. And it was a certainty from the administration that they wanted the death penalty to be available. And other countries just would not have contributed to if we were using the death penalty. That carries later on, once we're deep into the evidentiary process, brought a number of additional complications. A lot of other countries, and you can see in the open press, Malaysia, other places had stuff that we needed, people or evidence that we needed. And a number of countries would only relinquish evidence if we said it would be used in a non-capital case. So that was tough bargaining in a place where we were helped a lot by the State Department and the intelligence community. But there wasn't any serious sense of of a combined sort of trial, because there was no doubt that the intent was to reinforce that it was an attack on the United States. We have a functioning system, and it was appropriate then to bring justice through our processes. Talk a couple minutes about the investigative process. A key part of any criminal process then involves giving the defense the opportunity to test your stuff, to confront evidence, confront witnesses. And again, we don't literally have the Sixth Amendment applying, but the principles behind the Sixth Amendment predated enough and inform a process that it is important to be able to have, to be able to guarantee an independent defense. It is, for military people, a really sore spot because we got a lot of grief for a lot of generations about having a perceived railroad system. So it's only 30-some years ago that we set up a completely independent defense service, which I then had the great privilege of leading, where when you are working as a defense counsel, all of your supervisors are defense counsel. So it is the best protection against an ethical compromise that then makes people lose faith in the system and, of course, harms the person who's being tried. But because of the circumstances under which a lot of evidence of war crimes is discovered or created or handled, the rules of evidence and procedure for these kind of tribunals require modification, though they ultimately have to still ensure that the evidence and the processes are reliable. Let's take an example or two of just substantive evidence from the battlefield. The evidence that you take from the battlefield is generally not taken with much tidiness, and the soldiers aren't out there with the primary purpose of enforcing the law. They're there with the primary purpose of winning the war. So, the circumstances we had, soldiers go into a cave, finds Al-Qaeda stuff, pulls out a bag, shoves all the stuff in it, gets out of the cave, flings it onto a helicopter. That's an imperfect chain of custody, right? But really useful stuff in there. So there has to be some way to do both things, to not say, we're so fastidious that we're going to ignore evidence that is incredibly probative, but not have some kind of steamroller that keeps the defense from rightly testing it. Because if they don't do so, you don't trust the result, the client doesn't trust the defense counsel, and then you've lost the credibility of your process. So sometimes it's the actual stuff, but a great amount of the evidence seized is not itself classified, but it is the way we find stuff. We always hear people talk about sources and methods, and that is often the bigger concern. So, for example, we have come to know, and we came to know in that time, that there are circumstances in which U.S. personnel, from various elements of our national security apparatus, find themselves in countries where we don't want to acknowledge we are actually operating in cooperation with people from that country or other countries, for whom it's not good for their health or their country's politics to be known they're operating in places like that, but get really useful people or stuff. So the evidentiary rules, and they're not unique to the military, they're just a little broader in the military, provide for ways to navigate that by the government coming forward with affidavits from the senior people. It has to be the head of the CIA, not like a middle-level person, who certifies to a judge that this evidence was taken under these circumstances. And then any number of adjustments are available. You can introduce the evidence without any foundation. In other words, the judge just declares this is in evidence, or substitutes can be put together. But that is done. The government makes the case, our counsel make the case, present it to the judge, who considers it ex parte in camera, like the most secret, the most unbalanced way of considering evidence. But it's all in the compared to what scenario, compared to losing the evidence or otherwise. Then the judge needs to make a series of findings before admitting it into evidence. And the findings are relatively tough and strict. My point when I was supervising counsel in that process was we have to be able to use that as the last of last resorts for any number of reasons. Most of all, the credibility of the process and the fragility of the relationship with defense counsel. It's in the government's interest that the accused are well represented. So we would drill by looking through all alternatives, And then the final thing, of course, is just the real life that if you ask for it too much, you lose a reputation with the judge and you'll be looked at with more skepticism, and then you lose it when you really need it. But all of those adjustments, those rules, they're equivalent in the military of the Classified Information Procedure Act, do give a level of complexity, but give the ability for the United States to assert its national interest, pardon me, instead of just having the option of just not trying the case at all. One thing that was, I'm defensive of the military, I recognize, but just as you go through it, at the end I'll talk for a couple minutes about just a few thoughts I have on government and having experienced policy and everything over some number of years. But as we were writing the rules, there was an expectation by some of the senior people we were briefing that everybody would plead guilty. That we were killing ourselves thinking about these rules in detail because people would want to plead guilty anyway. I was sure they would not, for a couple of reasons. First is when you're in an effort like that, you don't want to be the first person to plead unless they really are giving you the deal of the century. Secondly, their clients, the incentive for a terrorist in Cuba to plead is not equivalent to one of somebody in the system in the States. But also there is a really strong, prideful culture among military counsel not to have the appearance of selling somebody out. So a plea would be really vigorously negotiated, and the first would be tough to arrive at. So the method of analyzing the likely outcome has to adjust to the reality of the circumstances we're in. So when we set out then to write the rules for commissions in September, October, up into the early in the following year, we really used a simple rubric of what's new since 1942. A unanimous Supreme Court had approved the processes that we just talked about with the Nazi saboteurs. So what we tried to think through, in my only simple way of thinking about it, was what's new, and then of all that stuff that's new, what do we care about? What is significant enough about it? The whole criminal law, criminal procedure revolution occurred in that number of years. It went from the Supreme Court nearly never taking a criminal procedure case for about a 20-year period that fills up most of your textbooks now. So the question was, out of all that, what would we change and what would inform the decision to change? So Miranda as an example, we weren't going to codify Miranda, which itself had remained, even at that time, a little controversial. But the question to take from that was how to prove the reliability of the evidence, and counseled us to pay attention to the way questions were being asked. Finally, even though Miranda doesn't apply, we're trying a case before a jury, and the jury has Miranda in its head because they're mature people who watch TV. So their sense of what the government ought to do is formed by the culture, separate from the best of instructions from a judge. Death penalty again carried particular complexities on when and under what circumstances we would use that. I mentioned it with regard to dealing with other countries and the limitations it placed on accessibility evidence. Obviously an issue for a Catholic person as well. It was clear that the death penalty had to be available. That was national policy in this case. So particularly now another 18 years later, with further clarity from the Vatican, the question would be whether or under what circumstances a faithful Catholic can participate in a capital case. And there's a lot of good thinking there about it. I had tried a capital case some number of years ago. The soldier had killed both of his babies 11 years apart, the only children he ever had. Neither made it to its first birthday. And we ended up not having to go capital, not having a reason for a sentencing proceeding because we didn't have a unanimous verdict. But here, you're dealing with, right, what does everybody say? I'm against the death penalty. But in this case, man, it really seems like it's called for, or if death were ever valid, right, it would be here. So, well, that's not a very systematic way of looking at it. We know we have some obligation to think that through. And I had to decide as a chief prosecutor, where the involvement would still remain appropriate. If I were not to walk into a courtroom with a case, which I occasionally did, but not always, to what extent am I advising, resourcing our counsel in thinking that through, and down to the final question of, can you use it for lawfully coercive purposes, right? I mean, one of the greatest values of the death penalty is to leverage it in any number of lawful ways to get a term of years or a plea for life. So this forum provided a lot of opportunity for that in a circumstance where it is most difficult to make a case for restraint or forbearance, particularly given the activity of the attackers to begin with. And we had, from a policy standpoint, thoughts all over regarding that. Same thing about defense counsel. It spent a fair amount of that fall just kind of running around briefing different senior people in the government, and one really senior, really profane, but really senior and smart guy turned to us in a briefing and said, why do those have any defense counsel at all? Why should we give these guys a defense counsel at all? And I was there with a senior military guy and a senior lawyer, and they both were like, you can take that question. But obviously to do that out of a self-interest that it's informed by an interest in justice. Last area then is appeals. I did criticize some of the political appointees who griped about being so tied to the Roosevelt order, that down to the dangling participle that Roosevelt used. We were using the exact wording for the Bush order, and thought we should have flexed it out some so we weren't just tied completely to that. But my sense, on the other hand, had been, in the Kieran case, they didn't get an appeal, so we shouldn't give appeals here either. It's an efficient process. It has its internal guarantees of justice, and good enough. So one of the people we were briefing was Will Taft, of the famous Tafts, and who was then the legal advisor to the State Department. I remember briefing him late in the day, and he had sort of a darkish office, and gone through all this stuff. And then at the end, late in the process, we were talking about appeals, and I said, no reason for appeal, this and that reason. And he was a really mild-mannered, wise man, and he just said, it's not all or nothing. You can just make up an appellate process as you choose. Then he talked about ICTY, the Yugoslav tribunal, and they had limited appellate rights, but they had some. And just said that has come to be such an essential element of justice and people's perception of justice that you ought to reconsider it. I thought, that's why they have smart people in government. And we changed our plan because of that, and did insert a labor of appeal. So looking ahead then, you could make the argument that the experience of these past 18 years, some number of cases have been tried, but the 5 main co-accused are not going to trial until January of 2021. So you could make an argument that the whole commission's process is a historical artifact that served its purpose through the mid-20th century, but is just not workable given our advanced sense of due process and particularly the intelligence community's security needs. I'd suggest that there are several post 9/11 decisions that tempt us to discard the mechanism, but that in fact a sort of Kieran plus our model would work. The 42 still unanimous Supreme Court decision, modified appropriately by the developments in the law that are enduring and important, so that not every change to the law, but those that are most significant, that we have kind of incorporated that into our concept of justice, that would then serve the national interest and advance justice, and not just guard against the compromise of classified information and stuff like that. And most of even the kind of the mainstream critics of the system always end up saying, but we still do need a process with some exceptions. So the argument is between the 40-yard lines in some ways. We also should be aware of and take advantage of, though it's a matter of a lot of debate, that war crimes trial or a series of trials or a timely series of trials can be an ideal mechanism to tell a story and to account to the people, to the United States for what's going on, and in an environment where the evidence can be tested. So the difference between even a 9/11 commission or a congressional hearing is that in a trial, you have people whose only function in the system is to test the evidence, not to be balanced, not as as like a co-prosecutor looking from another angle, but the only job of a defense counsel is to defend that guy next to you. And if we have some ability to, I think we should broadcast it on Al Jazeera, but to make these as available as possible, we have the non-trivial chance of reinforcing justice and showing what we stand for and showing those who might be open-minded and looking at our system a sense of how the system operates. But most of all, the narrative itself regarding the attacks and injustice. It sure worked at Nuremberg, that not only were key individuals brought to justice, but the world got to consume that and got to see that. And law students, if you have 26 free minutes, should just either Google up and read or YouTube up Justice Jackson's opening statement at Nuremberg. It's like in the best ever category of opening statements. So we should consider whether to do that, which greatly breaks our rubric. We have a really secure situation in Guantanamo that is almost unwieldy, and that we have like a literal curtain that comes down if somebody is said to be wandering into classified evidence and that sort of thing. And it's just the worst combination of logistically bulky and appearing to be, we can't have that kind of thing come out. Before I close, a couple of thoughts just from a practitioner standpoint and a citizen standpoint. For law students, my only piece of advice is there's never any wasted work, and think while you're doing your work. I just had the luck of having tried cases for most of my career and having been in the courtroom so much, on either side, dealing with motions to suppress and all of that. When we were then in the fall of 2001, where we would just get a snap announcement and say, be at a meeting with whoever to argue about the next iteration of the rules, somebody would toss off some comment about whatever, right to confront or something. And we needed to be able to respond at that time. So I didn't have any special skill. I just had lived with and thought about the process for a long time. So I was able to meet and argue with them a little bit. So when you're doing whatever you're doing and thinking, man, this is like my 10th memo on this or motion on this, you are marinating yourself in greater depth in those areas. So in that sense, it's not wasted, and your own just thinking of why am I doing this and what's the reason behind whatever it is can help you. A couple of thoughts as a citizen participant in this process. One is that citizenship itself matters and is a legitimate legal consideration and discriminating factor in the allocation of justice. Not always, and it sure doesn't mean people who are migrants here in the United States now, but in these circumstances with non-citizen, non-state actors, unlawful combatants, it is appropriate to argue and analyze in light of the rights that are not available to them. Regarding these cases, my sense is that if a case had been tried earlier, the result would have been different before the Supreme Court. When I ended up coming back to commissions that had been during a 3-year period where they were mainly in the appellate courts and the trial process had been stalled, And that is partly because the government was really secretive in the drafting process to begin with. So it had to be secret, but it was intentionally secretive so that there was nobody consulted in Congress. So when it was announced to the public, it was announced to Congress, and there were some number of senators in particular who were really, what I'd say, pro-defense senators, likely to have supported the process had they been consulted in some manner. Their having not done so then leads to litigation regarding the rules. Had there not been litigation regarding the rules, somebody would have tried some case, and it's a whole lot easier to be in the appellate process with a real record in front of you as opposed to just a book of rules. So that ended up having strategic consequences, I think, that has us in such a sluggish spot. On the positive side about how government works, that there is a place for imagination and collegiality. One is William Barr there writing away at Christmas 1988 trying to figure out how to get at this attack in Lockerbie. Another one would be somebody who we argued with a lot, but in a sort of productive, collegial way. The Vice President's Chief of Staff was really the brain behind military commissions this time. And he was just a couple steps ahead of everybody else, having thought through the process. He in particular being a real advocate for the unitary executive. So there's still an ability for like a person or two to make a difference in national policy. The consultative process was interesting, in learning one thing from each person that I had briefed. I mentioned the exchange with Mr. Taft in the State Department. At one time I briefed Secretary Rumsfeld and Wolfowitz, who was his deputy, and go through all this stuff. And then at the end, Wolfowitz just had one question. Are you going to take deals? Are you going to take guilty pleas from them? General Shinseki was the chief of staff of the army, and Gabe went through the same thing, went to see him, gave him a briefing, and his only question was, so what does it mean for our guys? What does it mean for our soldiers? If we are doing this, does this make them more vulnerable if they get captured, either under the law or just making it tougher for them to operate in certain environments? Also in that situation, we have to be attuned to public consumption. I had to spend some amount of time communicating to and through the press. And at one point, I went in there in a situation that had been sort of a mess in dealing with the press, and I was determined that I would never speak off the record, just in the idea that if I was going to say it, I didn't want to be an unnamed source or have other elements of the press play against each other, which worked okay. But I also, was kind of idealistic and pledged I wouldn't say anything except I knew to be exactly true. And then had made a decision to try this set of accused together. And we were back and forth on whether that was workable. So, Khalid Sheikh Mohammed and these other 4 individuals are still being tried as a cohort. That brings the normal complexity, about statements being used against each other and all of that. But it also avoids 5 trials, which should just be really a mess. But before we did the first arraignment of these guys, who had not seen each other in years, well, one of my counsel came to me and said, you sure we want to do that? And this could really be a mess in the courtroom and all that. And my instinct was, I think you're right. But we were close in time. There was another faction that thought, we should bring them all in there. We did bring them all in, and it was a real mess. It was like a reunion of terrorists. There were 5 guys kind of joking and fooling around in the courtroom. And the normal tools that you use to take control of the courtroom weren't there. So I realized I had made a mistake there. So then we had to do this press conference every night and went down that night. And Michael Isikoff of whatever, Newsweek or something said something to the effect of, wasn't that a really stupid decision and why did you do that? And I remember I think it was, what's the reasoning behind it? And I remember thinking as the words are coming out of my mouth, if I were really candid here, I would just say, man, I made a mistake and I won't do that again. But you had to figure a way to communicate that didn't make it look like we've lost control of this thing, and just talk about the measures we were going to have in place in the future and that kind of thing. Last couple of points, civilian supremacy. It is still, we did our arguing and we were welcome to argue as uniform counsel, but it was clear and it was appropriate that the decisions were all made by civilians. The military counsel are there in their own realm, but they are civilian decisions. It's also true when you look at, authority informed by experience and reality, that people change their minds and politicians change their minds. I was counsel then in 2008. President Obama was elected. He had made a number of statements about the military commissions process, that we have compromised our most basic values by having this mechanism there. So we knew it wasn't a friendly process necessarily, but we also knew that once he took charge on the 20th of January, he'd be in charge. So it ends up that we tried a case on election day, and we had been in this process of beginning to move along the cases. We had two cases, one really sensitive one, and kind of poignant one, set for trial. One was set for trial on the 24th of January, 4 days after inauguration. We ended up spending some amount of time, a lot of time, with his transition team at Department of Defense. They were a really impressive group of guys, that came in with the plan. The plan from the campaign was to shut down Guantanamo. And we just walked through case by case, charge by charge, not advocating for keeping it open or not keeping it open, because our job is to execute what the president tells us, and we were moving toward a change in presidents. And ultimately, we were told stand by the phone at noon on Monday, and it was the second thing the president signed was the order suspending operations down there. So we had spent some time in the time since the election talking to all of our counsel, all of our military counsel, making clear you don't get a vote, and your only mission in life is to prepare all of your information so that the new team can make its own decisions. And then once they reviewed the evidence, once they went to Guantanamo and walked in the confinement facilities and all that, changed their mind so that 3 years later, we're back in trial. So it's a lot of lost time, and you can always, there's no one cause for any blip, but you can do had we not done this, had we not thought that, had the rhetoric not gotten way ahead of reality, there would have been less dead time, trials would have been sooner, have a more credible process. To conclude then, I think our country is operating a system that is fundamentally just and strikes the right balance on key elements of due process, including independent counsel, published rules rigorously enforced by independent judges, and rules of evidence that rely as little as possible on evidentiary substitutes, but have the appropriate flexibility that such substitutes can be used in a method that is still just and appropriate. A process that produces timely and just verdicts means that those who seek to violate the laws of war face judicial as well as military sanctions. That then contributes to national security, contributes to the confidence of victims in the process, and the recognition by those with open minds that an essentially fair set of procedures and processes brought accountability. Thanks for your time.